great to welcome you back as we are continuing this series we're doing this summer, which is kind of an extension of some material we've uploaded before, having to do with the American Constitution, the American Republic, and the theme that I've been exploring here recently is what I'm calling the biblical roots of the American Republic. If you've been following along, you know we started by simply considering the fact that political machines in this world tend to either begin on the premise that there is God in heaven or there isn't. Those that start from an atheistic point of view will almost always, historically speaking, wind up in some kind of totalitarian situation where it's simply the exercise of raw power that governs the day. But of course, those political systems down through history that have recognized that there is a God in heaven and that truly our political institutions need to reflect that fact tend to take a different approach. Not always perfectly, in fact, I would say never perfectly, but at least to some degree there is a recognizable difference between those two approaches. So we've been exploring that a little bit, noting that if there is God in heaven, then in some ways we have to say that we come into this world on equal terms. God has created the human race, and there is a kind of unity that unites us. And so as we come into this world in what's commonly called in philosophy the state of nature, in which we're all more or less there having to make do for ourselves, we recognize that there's probably a more convenient way to order our lives, and that has to do with creating institutions of power, institutions of authority. But that authority needs to be governing, exercising its rights based on the consent of the governed. We create these institutions of authority, and of course they ultimately are answerable to us. And when they act up, then they should be held to account by us. And so we've been exploring all of those themes along the way. By the way, next week I'm going to be uploading what amounts to a focused discussion of the U.S. Constitution, especially arguing that the Constitution itself can be traced back to biblical sources as well. Some people think that's a pretty tall order and they're not sure we can pull that off, but I think it actually can be demonstrated quite compellingly that our U.S. Constitution had its roots in biblical ideas. I've seen articles, for example, calling the Constitution a godless document. Well, I don't think so. I think we can make a pretty good case that the framers of the Constitution and the people who orchestrated its basic divisions and meaning and so on had a very clear and distinct idea that there was the revelation of God that lay behind it. So I'm going to save that for next week, but just a little heads up that that's what's going to be coming. But this time I want to just wrap up what we've been working on so far, which is really tracing back from the American Republic these biblical roots. You know, I practiced law for quite a few years, and of course, most of what I did was called litigation. In litigation, we're especially interested in the procedures that are involved. Due process is the term traditionally used to describe how people who are accused of crimes, or even in the civil arena of litigation, should be given a fair trial, and there are certain rules that dictate what a fair trial looks like. And I guess my own interest in this leads me to want to do a little bit of a discussion on this occasion of simply the idea of due process and how due process really also was rooted in biblical sources. We've talked about that a little bit in the past, but I want to focus on it a bit more now. Also in this, I'm going to give a brief discussion of the notion of the sanctity of life. I don't need to argue that too vigorously. It can be easily demonstrated both from our constitutional documents and from the Bible. And finally, something of the division of labor, that is checks and balances, and the importance that that played as well in framing our Constitution. So that'll wrap up this little segment of what we're doing. As I say, I'll be focusing on the Constitution next week. And then after that, I want to expand this division of checks and balances, this conversation concerning that, and especially look at some of the branches of government as we find it in the Old Testament. The branches of government created by God's inspiration, by Moses, and it became kind of the substructure of the political operation in the Old Testament over the various years and centuries, indeed, of the Old Testament narrative. So that's what we have in mind. As I say right now, we're going to take up first of all this idea of due process. Due process was very much in the minds of the framers of the Constitution because they had a pretty fresh memory of the generations that had just preceded them, which had been exposed to a fair amount of abuse of due process in merry old England. You know that there were certain practices there. I'll just name a couple. The Star Chamber, for example, was well known as a kind of private trial, you know, where certain officials could get together, they could hold a trial. They didn't bother to mention it to the person that was accused. You know, they would just get together and present evidence and reach conclusions and render a verdict and sometimes pronounce a sentence. All the while, the person who was being accused had no idea this was going on. And then they would simply be arrested and served up the sentence that was imposed upon them. They had no opportunity to respond, to defend themselves. It was really a colossal breach of what we would call any sort of a fair adjudication. And the framers were aware of that, and they wanted to stay way clear of any such abusive policies. There was something in the English practice called bills of attainder. Bills of attainder are specifically repudiated in our Constitution. Some people don't know what that is, but a bill of attainder was when the legislative body would get together and again just kind of have a trial on its own and find somebody guilty as a matter of law, just pass a statute, as it were, to say that some individual was guilty. And as a result of that, they could be punished, incarcerated, and so on. And that sort of thing, of course, was really anathema to the people who were framing our Constitution. So they went out of their way to make sure that there would be basic rules that applied in the way that we do jurisprudence in this culture, and that those rules would dictate that people had an opportunity, if they were accused by the state of wrongdoing, they would have an opportunity to a fair trial and an opportunity to defend themselves, and all of that is what we call due process. You probably know that the Sixth Amendment of the Bill of Rights to the U.S. Constitution is probably the most clear in delineating the rules of due process, but it is sprinkled throughout the Bill of Rights, and in fact, even in the Constitution itself, you'll see allusions, you might say, to due process here and there. But the Sixth Amendment spells it out the most clearly, and so I'd like to just remind you of its content, and we'll be highlighting a few of the elements that we find here. But the Sixth Amendment reads, quote, "In all criminal prosecutions, the accused shall enjoy the right of a speedy and public trial." That's really the first point, a speedy trial, which is for the benefit of the accused. You can't be incarcerated for years on end waiting for a trial. And also a public trial. When I practiced, it was common to have an order or any sort of judicial decision or action take place, as the phrase went, in open court. Well, in open court was more than just poetry. You know, that meant that somebody could walk in off the street, John Q. Public, could walk into the courtroom, sit down, and observe the proceedings. And the very fact that this was happening in open court was a way of guaranteeing that the procedure that took place was not under the cloak of darkness, you know, some sort of secret proceeding that was unfair on its face. And so the first thing that is provided for in the Sixth Amendment, a speedy and public trial by an impartial jury. Obviously, Star Chamber, bills of attainder, such things had nothing to do with an impartial jury. A jury is someone who is supposed to be your peer, somebody kind of like you from the community, who can evaluate your situation and have a certain degree of sympathy with your circumstances and evaluate the evidence against you in a way that's fair and open and is going to meet the standards of some kind of proper procedure. The impartial jury is going to be derived from the state and district wherein the crime shall have been committed, or at least allegedly committed. It's not going to be a jury from far away, and you're not going to be hauled off to some place that's clear across the country to face a jury of strangers. You know, that was the idea. So the Sixth Amendment protects that as well. Which district shall have been previously ascertained by law. That's supposed to be spelled out in the rules that govern jury trials. To be informed of the nature and cause of the accusation. We view it as essential to a fair proceeding that you know that you're being accused. And more than that, you know exactly what you're being accused of. And it gives you an opportunity then, of course, to meet those accusations and to put together a defense if one is available, to be confronted with the witnesses against him. We view it as part of our fair trial that if somebody's accusing you, that you should be able to meet them, know who they are, cross-examine them, be able to find holes in their testimony to see where there may be insufficiency or bias or something like that that would influence the testimony that they're offering. And finally, to have compulsory process for obtaining witnesses in your favor, people who will speak on your behalf, and to have the assistance of counsel. A lawyer is provided to you at no cost if you can't afford one for his defense. It's a remarkable provision. We should all be grateful as Americans, if you happen to live in this country, that those kinds of protections are there. We've certainly seen abuses of some of those rules, but at the same time, the rules are there and they do stand as a kind of very important, weighty reminder of those things that are important to us in terms of how we view due process. Just going to say a word or two about some of these. First of all, a speedy and public trial. Back in England, early in the reign of Charles I, there was presented to him what was called the Petition of Right. The Petition of Right was actually put together more or less by Puritans. You know, the Puritans had been around in England for almost a half a century, something like that, in fact, going all the way through the reign of Queen Elizabeth, more than half a century, I guess you'd say, because the reign of James I is as well. So more of almost a full century, there had been Puritans growing, becoming more influential. They had a kind of tense relationship. Elizabeth was able to maneuver, navigate these Puritan influences. James I didn't like the Puritans very much, but he was savvy enough as a ruler to know that he needed to find some kind of accommodation with them, and he was pretty good at doing that. He was familiar with their views. He'd been reared as a Presbyterian up in Scotland before he became James I in England, so he knew what he was dealing with. He didn't like the Puritans. He wanted absolute monarchy. That was what he was angling for, but he knew he couldn't quite pull that off. And so he had a kind of a delicate diplomatic dance that he carried on, you might say, during his reign from 1603 to 1625. But when Charles I came to the throne, it was a very different matter. He almost immediately unleashed some very unfair processes and proceedings against the Puritans. And so early in his reign, about 3 years in, the Puritans put together this so-called Petition of Right, in which they pointed out to Charles the unfair character of what they were what the king was doing, and began to demand that due process be respected by the king. For one thing, they indicated that people were being detained by Your Majesty's special command. You see, the king would simply say, go imprison that person. No good reason for it, no justification for it, just do it, you know. And of course, the Puritans were often the recipients of such abuse, because a lot of what Charles was after was really aimed at the Puritans. He didn't like them, and he was really doing what he could to begin to try to really, you would say, persecute them, almost to drive them into non-existence by his policies. The Petition of Right pointed out that these people were returned back to the several prisons without being charged with anything to which they might make answer according to the law. Again, of course, pointing out the patent unfairness of such practices there in England. No speedy or public trial was being made available. You can see that all of these things were in the minds of the framers as part of what the abuse had been in their collective memory in the not too far distant past there in England. The matter of an impartial jury from the district of the alleged crime. Again, these who wrote the Petition of Rights were pointing out that no freeman should be imprisoned but by lawful judgment of his peers or by the law of the land. To simply arbitrarily put someone in prison when there hasn't been a proper procedure, of course, was viewed as a colossal miscarriage of what should have been afforded to them. Even the Declaration of Independence complains about George years later that he was transporting us beyond the seas to be tried for pretended offenses. Somebody would be accused of a crime and forced to go to England to stand trial for an event that, an action that took place in the colonies. And again, that was viewed as a significant unfair practice. The nature and cause of the accusation should be disclosed. Again, the Petition of Right pointed out that that freemen were imprisoned or could be detained only by the law of the land or by a due process of the law, and not by the king's special command without any charge. Again, objecting to the fact that the king had a kind of unilateral authority to pass judgment on people and impose penalties on them without some sort of due process. The right to confront witnesses was also very much in the minds of the framers. You may know the story of Sir Walter Raleigh. He was condemned to death during the reign of James I based on the written testimony of a single witness. Did you know that? And in fact, that witness, meanwhile, had recanted the accusation. And yet Walter Raleigh was nevertheless accused on that basis. Well, that's the kind of thing the framers, of course, couldn't abide, and that's part of what was driving the concerns that they were expressing at that time. Earlier, the historian Hallam, describing the trial of the Duke of Somerset, this was under Henry VIII, made an interesting observation. He said, "On how precarious a thread the life of every man is suspended, when the private deposition of one suborned witness, unconfronted with the prisoner, could suffice to obtain a conviction in the case of treason." I think you have an intuitive sense of just how unfair some of these practices were. Now the question is, where did the framers get the idea that there should be a trial in open court, that there should be a right to confront your accusers, that sort of thing? Where did those rules concerning due process come from? Well, the short answer would be they came in many cases from William Blackstone. William Blackstone, we've mentioned before, he was by far the most important jurisprudential scholar at the time of the framing of the American Constitution. English, of course, and he wrote a classic work called Commentaries on the Laws of England. I happen to have it. It's a 4-volume setting on my shelf, and it's a wonderful resource to read. There was a time in the United States when any lawyer was simply expected, if they were going to practice law, to be fully conversant with the Commentaries on the Laws of England by Blackstone. The 20th century saw something of a change in that with the effects of Oliver Wendell Holmes. We'll save that for another day, but nevertheless, William Blackstone at the time of the Constitution was certainly a very important voice. But he frankly acknowledges that his ideas about due process came straight out of the Bible. He gave ready and repeated acknowledgement to the biblical sources that lay behind much of what he set forth as the rules by which due process should be worked out. And so you'd say the framers, familiar with Blackstone, also understood that they were relying somewhat heavily on the biblical sources themselves. So I'd like to take a look at some of the more important features of the biblical instruction with respect to some of these issues. For example, in terms of due process, it was understood that there should be no partiality in terms of class or status with respect to people who are being accused. We mentioned earlier that Lady Justice, that great symbol of justice in our culture, is blindfolded. The very purpose of that is to make sure that, symbolically speaking at least, we understand that the judge doesn't have any respect for a person simply because of their social status, their class, their wealth, any such thing. That the merits of the case should be evaluated on the strength of the case itself and not on the basis of any sort of countervailing concerns that have to do with that person's aristocratic status or any such thing. Well, that comes straight out of the Bible. You know, Moses said in Exodus chapter 23, "You shall not show partiality to the poor man in his dispute." Again, in Leviticus, Moses writes, "You shall do no injustice in judgment. You shall not be partial to the poor, nor honor the person of the mighty. In righteousness you shall judge your neighbor." And again in Deuteronomy chapter 1, "Then I commanded your fathers at that time, saying, Hear the cases between your brethren, and judge righteously between a man and his brother, or the stranger who is with him. You shall not show partiality in judgment. You shall hear the small as well as the great. You shall not be afraid of any man's presence, for the judgment is God's. Now you might think to yourself, well, that's common sense. I mean, that doesn't say any great things about Moses. But, you can research this on your own, but I'll just tell you, if you go back and look at the rules that govern due process at the time Moses wrote those words, you will look far and wide for anybody that had anything remotely as advanced as what Moses set forth. And that's why his rules became such a paradigm throughout history for what due process should actually look like. Again, Moses established a principle that required a careful examination of the evidence. Of the evidence, meaning the objective evidence, the factual evidence that would either tend to exonerate or find the guilt of a person that was accused of a crime. Once again, you'd have to say that the insistence that Moses brought to the task in that connection was positively unique, really, in the ancient world at that time. Probably the most enlightened lawgiver known at the time was Hammurabi, the great Babylonian king. He wrote about 200 years earlier. There are some very modest correlations between Moses and Hammurabi, chiefly the lex talionis. But if you ask Hammurabi, what's a good rule for due process? How should we figure out whether a person is guilty or innocent of a given rule that Hammurabi had stated? One technique he suggested was haul them down to the river, throw them in, and see what happens. If they get eaten by alligators, I guess they were guilty. If they can make it to the shore, then they're innocent. He had other similarly interesting methods. One of them was to heat up an iron plate so that it was red hot, and then put it on a person's tongue, and the tongue would blister, of course, under that intense heat. And then the examiner would take a look at the tongue and see how it blistered. And if it blistered in a certain way, it meant the person was guilty, and if it blistered in another way, it meant the person was innocent. He had other kinds of practices like that. And I think most of us would be a little bit suspicious of a principle of due process that used those particular methodologies to establish whether you had been violating a given rule or not. Moses had nothing like that. Moses had a clear, consistent, and a repeated insistence that the actual facts of the case should be examined. He said, for example, in Deuteronomy chapter 13, "You shall inquire, search out, and ask diligently." Again, in Deuteronomy chapter 19, "One witness," one emphasis there, "shall not rise against a man concerning any iniquity or any sin he commits. No, it's by the mouth of 2 or 3 witnesses the matter shall be established." Moses required in major crimes that more than one witness must come forward with a description of the alleged crime, and those 2 witnesses, or 3, or however many there may be, had to agree in the details of their testimony. Didn't have to be perfect agreement, but it had to be substantial agreement in order for the person to be found guilty. And of course, that is one of the most important principles of due process that Moses spelled out, and certainly it speaks to the broader issue of a fair hearing. He continues, "If a false witness rises against any man to testify against him of wrongdoing, then both men in the controversy shall stand before the Lord, before the priests and the judges who serve in those days. And the judges shall make careful inquiry." See the importance of a careful inquiry, adjudication in detail of the facts that are being alleged, and to make sure the evidence matches the accusations. A careful inquiry. "And indeed, if the witness is a false witness who has testified falsely against his brother, then you shall do to him as he thought to have done to his brother. So you shall put away the evil from among you." You have to say if somebody came along and was bearing false witness, hoping to do damage to somebody he didn't like, if that came to light, then the damage he hoped to do would be done to him. It's a very elegant kind of rule, and that sort of thing is certainly a way of simply saying that there was going to be a close examination of the evidence in order to determine whether or not the allegations met with some kind of objective measure of the facts of the case. Multiple witnesses, as we've already suggested, would be bound by their conscience. Again, one witness was not sufficient to find a person guilty. Even if you were standing 5 feet away from a murder that took place and you saw it with perfect clarity, if you were the only witness to it, your testimony, however convincing it might be, was going to be insufficient to find that person guilty. That's a very high standard of due process, you know. Again, in Deuteronomy 17, whoever is deserving of death shall be put to death on the testimony of 2 or 3 witnesses. He shall not be put to death on the testimony of just 1 witness. The hands of the witnesses shall be the first against him to put him to death. The witnesses here who are bringing this accusation have to put their actions where their mouth is. They have to be willing in good conscience to stand up and be involved in executing the person who has been condemned based on their testimony. Afterward, the hands of all the people. So shall you put evil away from among you. The trial was to take place in open court. Again, the reason for this is because it's much harder to have a kind of a kangaroo court, you know, when it's open to the public. So we read in Joshua, for example, when he flees to one of those cities, referring to the cities of refuge, and stands at the entrance of a gate of the city, and declares his case in the hearing of the elders of that city, they shall take him into the city as one of them and give him a place that he may dwell among them. This is in case of an accidental death. You know, something happens where someone is accidentally killed by the negligence of another person. He can flee to the city of refuge and find safe harbor there until the trial. But notice the trial. He shall dwell in the city until he stands before the congregation. The congregation was another word for the public. This trial is not going to take place in secret. It's going to take place out in the open, and people are going to be able to see what's going on and evaluate whether or not a fair proceeding is being offered to this person before the congregation for judgment until the death of the one who is the high priest in those days. The trial was to be speedy, and it was to be inexpensive. Again, Moses says in Deuteronomy 16, you shall appoint judges and officers in all your towns. We might call the judges in a small town something like small claims, you know. You don't have to go 100 miles. You don't have to spend a lot of money in order to have your case heard. You have somebody right there, local, that you have ready access to for purposes of hearing your case and the allegations of wrongdoing. And that's a rather remarkable advantage to provide. You know, when I was practicing law, it was almost embarrassing how expensive it could be to try a case. And I have to say, we could learn some things from Moses, you know. I had to tell people sometimes, you know, their case could be brought and it might be a year or two before it would make it to trial. And by the time you've hired a bunch of experts and done everything you need to make a credible case, you know, it can add up to a fair amount of money. Well, in Israel, there was an attempt to make sure that at least at the beginning, the case could be heard with relative speed and relative lack of expense. And that certainly is one of the great principles of due process that Moses enshrined for us. Again, when Jethro was talking to Moses, you remember Exodus 18, he said, quote, moreover, look for able men from all the people, men who fear God, who are trustworthy, who hate a bribe, and place such men over the people as chiefs of thousands, of hundreds, of fifties, and even of tens. We have judges that can adjudicate just a very small number of people, and then you go up from there based on the nature of the case and so on. And so all of this, of course, tells us how important due process was at that culture and at that time. There's also a accommodation for gradations of guilt. William Blackstone makes specific reference to this very illustration that Moses himself provided back in Deuteronomy 19. If anyone kills his neighbor unintentionally, accidentally, without having hated him in the past, as when someone goes into the forest with his neighbor to cut wood, and his hand swings the axe to cut down a tree, and the head slips from the handle and strikes his neighbor so that he dies, he may flee to one of those cities of refuge and live. This is what's called in the law negligence. Now, there may be liability, you know. If you were negligent in not making sure the axe head was on there as well as it should be, you might have some exposure, but you're not going to die for this. The accidental death of someone is not going to give rise to a death on your part, although there may be damages of some kind. We have the same kind of rules ourselves. However, If you had what's sometimes called malice aforethought, you had a premeditated interest in killing somebody, then that changes the game considerably. If anyone hates his neighbor and lies in wait for him and attacks him and strikes him fatally so that he dies, and he flees to one of those cities of refuge, then the elders of his city shall send and take him from there and hand him to the avenger of blood that he may die. If he's found guilty of intentional murder, where he hated the person, he wanted them dead, he carried out a plot to make it happen, then obviously that represents a much more important crime and gives rise to capital punishment. Well, all of this is simply to say, I think you can see that Moses had a quite well-developed idea of due process. And when the framers were enshrining the notion of due process in our system of justice, they were relying rather heavily on Moses and certainly relying on other authors and scholars down through the years who had articulated some of the principles that would apply in such a case. The next element I'd like to look at is simply sanctity of life. I think you understand that I don't need to say too much about this because there's really no need to. It's so painfully obvious that I just want to mention it to you to make sure that we don't forget it in the process. But the idea of life being sacred, life is something God has given. And by that very fact alone, it's something to be guarded and protected, was certainly an important idea to the framers of the Constitution, and we certainly find it represented frequently and indeed repeatedly in the biblical sources themselves. The Declaration of Independence, as you know, states right off the bat, we hold these truths to be self-evident. Men are created equal, and they are endowed by their Creator with certain unalienable rights, and among them is first and foremost life, and then liberty, and then pursuit of happiness. The Constitution makes a similar kind of reference to life. This is the Fifth Amendment to the Bill of Rights of the Constitution, in which you may notice about halfway down, nor shall any person be subject for the same offense to be twice put in jeopardy of life. That's called double jeopardy. You can't be tried for the same crime twice and put in jeopardy of life. And it continues, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. How central is the concern for life, of course, and so we're not surprised to see that. Again, in the 14th Amendment, a similar provision. No state, now the Fifth Amendment applied to the federal government. Here we have the 14th Amendment applying to the states now. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. Do we find something like that in the Bible? Well, I hope to shout, this is one of the most important ideas that we find in the Scriptures. The Ten Commandments itself, of course, rules against murder. Thou shalt not kill. This is one of the most important principles. And the idea of the sanctity of life is just repeated again and again. I don't need to labor the point, I don't think. It even extends to unintentional loss of life. Again, there is a distinction here at the point of negligence versus intent. But even life that is lost because of a negligent act is still going to be held to a very high standard. We talked about that a moment ago. So you have, for example, in Deuteronomy chapter 22, Moses says, when you build a house, you shall make a parapet for your roof, that you may not bring the guilt of blood upon your house if anyone should fall from it. The houses back in that day tended to be flat roofed, and it was common for people to go up on the roof, and they could go up there in the evening, maybe eat or meditate or whatever. But the rule was that you built a little fence around the perimeter of the roof so that people wouldn't accidentally fall off the roof and injure themselves. And again, you can see the importance attached to life. Like I say, I'm not going to labor this more. I just wanted to remind you that that's a part of our conversation. Finally, checks and balances. This is really at the heart of American governance. Our whole system of government is based on the idea of limited jurisdiction, balance of power, checks and balances. James Madison is called the father of the U.S. Constitution. He went to what became Princeton, College of New Jersey, which was under the presidency of John Witherspoon. John Witherspoon was a Presbyterian. He was an immigrant from Scotland. He was a scholar and a pastor, and he was the president of the school. He was so impressed with James Madison that he kept Madison around for an extra year, and after Madison had graduated, he actually gave him advanced training in Presbyterian understanding of government. This is what Witherspoon was about, and he saw in Madison a huge amount of potential, and I think he anticipated Madison would probably be an extraordinarily important personality in later history, the colonial history, and eventually, of course, Witherspoon didn't know it at the time, but the Revolutionary conflict itself and the framing of the Constitution. But anyway, this advanced training, of course, took hold. And Madison had a very Presbyterian and Calvinistic understanding of the role of government. In Federalist 10, written by James Madison, he made the famous remark, if men were angels, no government would be necessary. Angelic personalities aren't inclined to sin, and thus you wouldn't need that kind of governmental control. But of course, his point was men are not angels. Men are broken people, and you can't trust them. And especially if you give people power, then you need to have some pretty significant limits on the extent to which that power can be exercised, because people given power tend to abuse it unless there are constraints that are applied to them. And so in many ways, the entire Constitution was framed on the premise of making sure nobody gets too much power. That was precisely what was going on. That's why you have such intricate definitions of limitations of power, the three branches of government, distinctions between federal and state government, and so on, all of those that you're familiar with. We'll look at more of that as we go along, but just by way of mentioning it now, that was part of where this notion of checks and balances came from. It came from that training that Madison had, and of course all of it ultimately derived from the Bible. In other times in history, we see a similar thing. The Glorious Revolution in England of 1688 was the final death knell to what you would call absolute monarchy. It had never been absolute monarchy exactly in England as it had been in France and elsewhere, but there was always an inclination by the British rulers to try to get as much power as they could. Certainly James I did that, Charles I even more so, Charles II after the interregnum, James II, all of these guys were vying for more power. And finally, the Glorious Revolution under William and Mary, 1688, put an end to it. And that was the establishment of a true, overt constitutional monarchy, in which the monarch was as much a subject to the law as anybody else. Well, here in the colonies, we decided not to go with monarchy at all, but we had the same principle, a constitutional republic which would be rooted on the rule of law, and nobody is going to be able to exercise authority that rises above the parameters of what the law permits. This was conspicuously absent, for example, in the French Revolution of the late 17th century, or the 1700s, and the Communist Revolution, the Bolshevik Revolution of Russia in the early 20th century. Both of them were atheistic in their basic premise. The French, of course, Revolution basically made reason, Lady Reason, you might say, the goddess, and they operated on the premise that people are basically good. Well, I'm going to tell you, as lovely as that may sound, it will ultimately lead to a bloodbath, as it did in France, as it did in Russia, and as it did anywhere it's been tried, where people try to have a utopian delusion about the human situation. It's going to have a bad ending, and we've certainly had the testimony from history. That's what Madison was trying to avoid. And so the reason that we have all of these limitations on power is precisely to prevent that kind of abuse from taking place. Well, do we find that in the Bible? We certainly do, and as I said, I'm going to come back to this theme in some greater detail in several weeks as we go along this summer, looking at some of the specific branches of government in the Hebrew Republic. So right now I'm not really giving you details, I'm just going to give you kind of an overview snapshot of what we're talking about. But there was, as you know, as we've already discussed, an attempt to sort of equalize authority. The very fact that everybody was to have a perpetual interest in the land, that it wasn't going to be owned by one person. It was an attempt to more or less create checks and balances back in the Hebrew Republic. The authority of the judges in Israel was balanced by the authority of the Senate, you might say, the Sanhedrin. I'm just giving you a quick snapshot. There's much more to be said on this, but just by way of introducing the idea. Some people have mentioned that, well, the Levites, they were given special kind of recognition. They had more authority than the other tribes, but not so much. You know, there's an old expression, knowledge is power. You've heard that. And in some ways, that was what was given to the Levites. They were given the power that comes through knowledge, but they were not given the power that comes through property. And so while most of the tribes could enjoy power that derived from property ownership perpetually, the Levites were not given that kind of perpetual ownership of the land. They were indeed given a stewardship of knowledge. And so while they had more power in the area of knowledge, they had less power in the area of the property ownership in the land, and that, of course, was a way of balancing power as well. So we have all of this. By the way, the Levites were also scattered throughout the region of Israel, so that they had no particular homeland where they could more or less consolidate their interest in that sort of thing. So again, if you look at the way in which the Hebrew Republic was organized, it didn't have this kind of checks and balances idea going on. As I say, we'll talk about that more on a future occasion. Bottom line, we do have a rather sophisticated notion of due process, which was part of the Hebrew idea. We had a high estimate of the value of life, and we had this rather elaborate system of checks and balances, and all of that filters into our American Republic and forms part of the biblical roots of the American Republic. All right, well, next time we're together, I'm going to take a much more specific look at the Constitution. Some people say, well, you know, you read the Constitution, God isn't even mentioned, you don't have any religious elements there. In fact, there's a specific prohibition against religious tests. And I've seen people argue in academic journals that therefore the Constitution should be construed as a godless document. You know, this is a godless kind of approach to governance. And certainly the Declaration of Independence should not be regarded as part of the Constitution. Well, I'm going to take on all of those issues. I hope that you'll be able to find your way back at that time, because I think that this is one point where we who consider ourselves Christians should really have a pretty good understanding of what's actually going on in the roots of our republic. And it certainly will give us some additional insight into how we should be living out our lives, and how we should be holding our representatives and elected officials to account as well, as we continue to be responsible in our own culture. Thanks for joining. I appreciate it. It's great to have you along. Hope to see you next time we're about this business, and until then, I hope that God will continue to richly bless you and yours. Thank you. Bye.